The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
Rebecca and Jake Harrow's claim of a terrifying abduction shattered lives and unleashed a horrific investigation. On August 14, 2025, 7-month-old Emmanuel Harrow vanished from a Yucaipa parking lot. His mother reporting that she'd been assaulted while changing his diaper and awoke to find him gone. Investigators later disproved the kidnapping story, uncovered inconsistencies in Rebecca's account, and revealed that baby Emmanuel had likely died after prolonged abuse. The couple was arrested on murder and false report charges, while authorities continue searching remote terrain for his remains. Now Jake Harrow has admitted his guilt, and Rebecca is getting ready for trial, while the world still wonders, where is baby Emmanuel? But first, on September 10th, 2025, conservative activist Charlie Kirk took the stage at Utah Valley University before a crowd of 3,000, and moments later, his life was stolen by a sniper's bullet from the rooftop. Investigators allege that Tyler Robinson, 22, tracked Kirk's movements, wrapped a rifle in a towel, engraved bullets with taunting messages, and chose that exact moment to strike. Police say DNA evidence, text messages, and surveillance footage linked Robinson to the weapon and to the scene. He now faces aggravated murder charges, with prosecutors seeking the death penalty. As the nation braces for the trial, the defense wants to shut the public out of the courtroom. Will America see the Charlie Kirk assassination trial? I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. Great to have you with us. The killing of Charlie Kirk was a public assassination, and that's an important part of this case, the investigation, and an important part of the trial. There is a level of public investment in what happened. You had 3,000 people there who witnessed what happened, and that was just in person. You had millions around the world who saw what happened to Charlie Kirk, and it has incredibly huge social and cultural implications. So there's an incredible public interest, but a public investment in this case. So, of course, lots of media, lots of attention. Everyone's talking about it on social media. There's videos everywhere, including video of the actual killing. But let me just state tonight, right here, right now, because I know you're going to hear the jumping up and down by the defense attorneys for the accused killer. He will get a fair trial, period. That's the way our system works. They will complain that they're not going to get a fair trial. They're going to jump up and down and talk about pretrial publicity, and they're going to talk about cameras. They're going to talk about social media. They're going to talk about AI. They're going to talk about all these different things. And it's what defense attorneys do, and I expect it. But, like, really, at this point, I've heard enough of it that I don't take it seriously. Just look in history. We've had big cases before. Now, I don't know how large or how big this case will be, but O.J. Simpson was a big case. O.J. Simpson got a fair trial. O.J. Simpson was found not guilty. The woman down in Orlando was public enemy number one, the most hated woman in America, convicted by the evil media, convicted by the court of public opinion. She got a fair trial. She was found not guilty. And you can get a fair trial and be found guilty also. Just because you're found guilty doesn't mean you didn't get a fair trial, especially in cases where you did it. Okay? So when you start hearing all that noise, just take a step back and say, okay, I get it. It's a defense attorney doing their job. But is it real? Is he really not going to get a fair trial? No, he will get a fair trial. There's a thing called voir dire, where jurors get questioned about what they know. Jurors have to provide answers. They have to be truthful. The attorneys have an opportunity to question them. And in cases like this, they'll often do a little bit of research about the prospective jurors to find out more about their background. So let's just put that aside. There's something else about this case that is happening. You've probably seen it online, the internet, social media, a lot of wild conspiracies out there. Now, are they true? I don't know. We're going to have a trial. What prosecutors are telling us seems to be a relatively strong case. What they're talking about videos, they're talking about confessions, they're talking about DNA, they're talking about ballistics. It's like they're dotting all their I's and crossing all their T's in what most prosecutors don't have in most of the cases that we cover here on Court TV. That being said, people are allowed to express their opinions about what they saw on video or what they didn't see, what they heard, what they didn't hear. So those conspiracies are out there. What is the best way to have them simmer down a little bit? What's the best way for the people of the country who are invested in this case to understand the evidence in the case and to be satisfied and understanding what the evidence is and was and the result of the case? You need transparency for that. A case like this, you need, the conspiracy theories are already there. And again, they may be true, they may not be true. I don't know, I haven't investigated them. But if you turn this into a secret trial where only a few people who can, win a lottery ticket out at the courthouse and take off from work, take off from school, and take off from life to watch the trial, if they're the only ones that see it, those conspiracies will grow even larger. I'll guarantee you that. But if you have a public trial and you get to see it and hear it, like all the public trials we have here on Court TV, you have a much better chance at having the public trust the outcome, understand the outcome, and trust our system of justice. With that said, let's go back to September 29th, Judge Tony Graff. And this was very good to hear from the judge, because what he's saying sounds like he gets it. Take a listen.
Let me be clear. I will not put my finger on the scale of justice. These proceedings will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys and participate in these legal proceedings. Counsel, regardless of who is watching, whether it is the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. I encourage each of you to give your very best to this case. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice.
Saying all the right things, this will be open to the public in accordance with the law. What's the law in Utah? The law in Utah is that there's a presumption that cameras and microphones are permitted in the courtroom. There has to be some sort of compelling reason to keep them out. Some compelling reason. And I know what's going to be argued. This is the biggest trial ever, Your Honor. The biggest trial ever. That's the compelling reason. Every trial we cover on Court TV is high profile. Every one of them. Some are nationally high profile and some are locally high profile. But all of them are. And everybody gets a fair trial. We see it. Sometimes they're guilty, sometimes they're not guilty. Depends upon the evidence, depends upon the jurors, the way they see it. It doesn't, oh, all right. I'll get off the soapbox for a second. All right, now, so now it seems that the defense, as usual, on cue, is going to make some attempt to keep cameras out of the courtroom. Take a listen to what happened inside of the courtroom.
Mr. Robinson, I understand, is appearing by WebEx. Mr. Robinson, can you hear us?
Yes, I can.
The sheriff's and Mr. Robinson's request to limit or exclude visual recording and photography in the courtroom. And finally, the fourth matter, the state's request to have all non-evidentiary hearings held remotely. The parties have stipulated that the state's request to hold non-evidentiary hearings virtually, as well as the parties' joint request to limit electronic media coverage, both require further briefing. Those issues are not yet ready for the court's decision. To facilitate that briefing, the court directs as follows. If the state wishes to have all non-evidentiary hearings conducted via WebEx, it must file a separate motion. The court will not rely on prior briefing. The standard timelines for response and reply apply, and the parties must file a request to submit and request a hearing if desired. If the parties seek to limit or restrict electronic media coverage, they may file a joint motion. Again, the court will not rely on prior briefing. That motion must address the factors set forth in Rule 4-401.01 sub 2 of the Utah Rules of Judicial Administration. Standard response and reply times apply, and the parties must file a request to submit once the matter is ripe for decision. I wish now to also address the decorum and media restrictions. To mitigate any potential prejudice, the court will amend its standing decorum order. The media will be prohibited from photographing or visually recording Mr. Robinson's restraints and from photographing or recording him while entering, exiting, or standing in the courtroom. In making this amendment, the court has considered the factors in Rule 4-401.01 sub 2. This is a high-profile case with strong public interest. Restricting the recording of restraints strikes the proper balance between Mr. Robinson's right to a fair proceeding and the public's right to access and transparency. Additional time is needed to complete discovery and to file motions addressing whether non-evidentiary hearings should be conducted virtually, whether to impose any blanket restrictions on cameras in the courtroom, and any other motions that may arise. This matter is set to return before the court on January 16th, 2026 at 1 p.m. and again on January 30th, 2026 at 1 p.m. Both hearings will be heard and held in person with Mr. Robinson present to address these issues.
Okay, now did you hear that? It's not just the defense. Apparently it is the prosecution and also the sheriff's office that want this blanket ban of electronic media from the courtroom in a public trial with this much public investment. Let's bring in our think tank. They may disagree with me. I never know what they're going to say. Let's bring him in. Criminal defense attorney, former head prosecutor, New Jersey, Bob Bianchi. Former police lieutenant, trial attorney, Rick King. National parenting and family relationship expert, Dr. Sue Kornbluth. Great to see everyone tonight. I just want to make my position very clear. I understand I work at Court TV, but I chose this work. It's not like I got drafted. I chose to work here because of what I believe in. And I remember being a prosecutor and watching what would happen on sentencing day on Fridays, where all these judges would just give these guys 10 chances, 11 chances, 12 chances, and never put anyone in jail. And the public had no idea what was happening. It was that moment, a little light bulb over my head. Man, there should be a camera in this courtroom. And then guess what happened? Court TV was born soon thereafter. All right, Bob Bianchi, I don't know what you think. You may agree, you may disagree. But I am shocked that prosecutors who work for the government, work for the state, don't want the public to see what's happening here?
Makes no sense to me, Vinny. As a prosecutor who's tried cases with a single feed camera in a courtroom, completely unobtrusive. It's not an OJ scenario, which the courts always point to, where things were completely out of control. The public has a right to know. The judge is striking, in my opinion, the balance, the transparency. Listen, why in today's day and age do I have to get what's going on in a courtroom? It drives me nuts in federal court that I got to read somebody's reporting on what somebody's saying, which 90% of the time isn't even accurate, or they're not even getting the salient facts. That not have a court, why the prosecutors are not allowing a camera in the courtroom befuddles me. It should be allowed this way, especially in a case like this. There can't be these conspiracy theories that something's being hidden from the public. It's an outrage. Prosecutors are dropping the ball on this one.
Yeah, I think we're all on the same.
I disagree.
Go ahead, Rick. You disagree.
Good. So, Vinnie, I disagree. And on behalf of the defense bar, I'm going to tell you I take some umbrage with what you say. So here is whether or not we are going to jump up and down and talk about, fair trial. We do that for a reason. Just look at if you just look at the setup of the courtroom, you have the government who gets to call themselves the state of Utah, or we're here in Florida, the state of Florida, sitting cozy up next to the jury. You have the judge sitting up on high above everybody else, taking care of the proceedings. And then in the corner, you have the defense table with the defendant sitting far to the end, next to the door and next to the deputies ready to take him out the door. So everything is set up to make the defendant appear to be the evil one. When people get arrested and you find out, hey, it was your neighbor that was just arrested, you don't say, oh, it's probably not him. What you say is, oh, I'm glad they caught the guy. While this is problematic from a transparency perspective, I get that. At the same time, there's a balancing act between the rights of the fair trial rights of the defendant. There's also the integrity of the process, safety concerns, and the public's right to know. You have to balance those things. And I think on some level, in a case this large.
But Rick, this is our system of justice. First of all, the judge sits in front of two tables. One table has to be one place, and another table has to be another place. The fact that there's a TV feed in the courtroom does not deprecate the defendant's right to a fair trial. It just doesn't.
I think.
Why can't we switch?
Because I think that it is important in this case that this is made public. Every single person out there experienced what happened to Charlie Kirk on that day. Whether this man is innocent or not, I don't see any reason to not have this public. Every other case has been publicized. I mean, Vinnie, you talked about the OJ case. We all followed that on TV, and it was made public to the world. And I don't see any difference here. We all experienced that day. It was traumatic for everyone. And I think we should be able to watch this.
Vinnie, can I add one thing?
People act differently.
One point. But Vinnie, I just recently had a homicide case where a defendant, they dismissed the charges against them. No media, no fanfare, no courtroom cameras. And so on the internet, for the rest of that person's life, it'll be this person accused of killing his child, when in truth, he did not, because there wasn't transparency, because the cameras weren't in the courtroom. So it's good for the goose, it's good for the gander. If he's presumed innocent, and in fact, the jury comes back and says he's not guilty, that inures to the benefit of the defendant to show the world the evidence in which acquitted him. Go ahead, Rick. Are you starstruck? Are you no response?
I was just going to say, the question that I wanted answered was, if everything is so fair, then why not bring the defendant out in the orange jumpsuit and the shackles? Because it's the perception. It's the perception of what he looks like. That's why the judge ruled against that. And again, why not switch tables? Why not let the defendant sit next to the jury sometimes? We don't do that because the system, whether you like it or not, is set up to put that defendant in the corner. That's why.
I agree with you, Rick. I agree with you. That is called an anchoring effect, and it's a psychological term.
Lawyer. Let me put a button on this. Rick, I think we all agree. because you feel like the system might be rigged. What better way to expose the system than to show people what is happening in the courtroom? That's the whole point of transparency. You let the sunshine in and the disinfectant comes in and we clean up all the mess. There's no backroom deals. There's no like, oh my goodness, they did this, they did that. If someone's acting improperly, people can see it. If the evidence is there, people will hear it. If the evidence isn't there, the people will hear it. Could you imagine if let's take, for instance, Karen Reed, no cameras in the Karen Reed case, and it's just like people reporting. Well, it would depend upon whose report you were listening to as to what case you were watching, because I was watching the reports of people from there, and some people saw one case, some people saw another case. So, but if you got to watch it yourself, you make up your own mind and you understand, and it puts trust in our system of government, our system of justice, which is needed because it's at an all-time low. I trust the think tank. They'll be here all night. Up next, we're going to talk more about some of the rulings by the judge relative to the Charlie Kirk assassination trial, plus coming up next hour. Tonight on Vinnie Politan investigates a mother's cross-country drive and a little girl who never made it home. Tonight, the desperate search for 9-year-old Melody Buzzard stretches from California to Nebraska, and the questions surrounding her mother's silence. What really happened on that long, mysterious trip? Tonight, we investigate.
The Court TV podcast will return.
You see the suspect ran behind that upper building. He's going to come out on the right, moves to this far right corner. As he does, he's going to climb off the edge and then drop down to the ground. As he did that, he left some palm impressions. There's some smudges, some places we're looking to collect DNA. There's a shoe imprint. It's clearly identified as wearing Converse tennis shoes. Again, we'll replay that again so you can get another view of that.
In this case, it seems from what we've heard so far and what we've seen that there is some potentially compelling evidence against the accused assassin. Like, it's just there. Like, it's everything you want. It's the ballistics, it's the DNA, it's video, it's an alleged confession, it's text messages, it's everything that you would want as a prosecutor in presenting a case. Now, they were in court yesterday and they were arguing about some of the issues that we've been discussing, which is, you know, what is he going to look like when he's inside the courtroom? What can they show? What can't they show? Let's take a look at this report from Scripps News Group reporter Ben Winslow.
These are some big rulings when it comes to what you can see in and out of the courtroom. Tyler Robinson's attorneys argue they're necessary to avoid pretrial publicity and be able to seat an impartial jury. So far, this is the only image you've seen of Tyler Robinson in court. He's accused of killing conservative influencer Charlie Kirk at Utah Valley University back in September. His lawyers want him to appear in civilian clothing and unshackled to avoid pretrial publicity. They point to an avalanche of news and online discourse about the case. Here's what the judge decided.
The court finds that Mr. Robinson's right to the presumption of innocence outweighs the minimal inconvenience of permitting civilian attire, and Mr. Robinson shall be dressed as one who is presumed innocent. Accordingly, the defendant's request to appear in civilian clothing for all pretrial proceedings is granted. Mr. Robinson also requests to appear unrestrained during pretrial proceedings. He argues that visible restraints would prejudice potential jurors, undermine his dignity, and interfere with his ability to communicate with counsel. The charges he faces are extraordinarily serious, carrying potential penalties of life imprisonment or death. The safety of Mr. Robinson, the attorneys, court staff, and the public must remain the court's highest priority.
Okay, this is very common, right? Pre-trial, you try to limit what the public can hear, et cetera, et cetera, et cetera. Rick, I'm going to point something out, and I usually don't help the defense bar. So I'm going to let him in on a little secret here. The more information that comes out, the better for the defense. Why is that? It's simple. Because of this thing called voir dire, and we question jurors beforehand. If you let all the evidence out, right, and there's someone who still, despite hearing all this evidence, or is either living under a rock or whatever, you're left with the remainderment, like the people that, like, these are the people that defense attorneys love. The outliers of society who have not come to a conclusion despite the fact of all the evidence that has been made public. Like, that's who you want. You want the people who either know nothing or, like, don't believe any of it and are going to presume him innocent despite all this overwhelming pretrial evidence. So you guys should fight to let it out, not keep it back, Rick. If you guys were smart.
I'm writing this down so I don't forget. It's because so I know for my next trial. However, my thing to you is, for the most part, those people don't exist, man. Like, you know.
Yes, they do. There were 12 of them in Pinellas County, Florida. In the Casey, I'll say her name, in the Casey Anthony trial, you had 12 people. They were like the outliers of society. I don't know where they came from, but she was the most hated woman in America. How many people got dismissed because they had their opinions? And rightfully so, like I did, right? I couldn't have made it onto that jury. You didn't want me, but you may have wanted that guy who didn't know anything or said, that's not real evidence.
Vinny, those people don't exist. And here's the thing. And what you're saying is absolutely, like, I love what you're saying, because here's what it is. When you have someone come in there, and let's say that you're right, those people do exist. They don't know anything, but then they come in and they see Mr. Robinson shackled, and they see him.
No, they've already seen him on TV. We already showed him on TV. They saw him, and they still, no, that doesn't mean anything. No. Those are the people you want.
Yes, it does, Vinny. No, it does. I'm sorry, Vinny. This means a lot. And we're going to look at this from a psychological perspective right now. This man who is on trial, he is presumed innocent, okay, until proven guilty. And so he has a right to come into that room in his clothing. And by the way, what we know psychologically is when somebody walks into a courtroom in their orange jumpsuit, something goes off in our brain because we have what are known as schemas. And it says to us that this person may be very guilty. And it's just by looking at that orange jumpsuit. So there is yes. So this is a major point to consider here.
Is that what Vinny's talking about, though? I don't think being in the orange jumpsuit is what we're talking about here.
Add on the shackles.
That's what I'm talking about.
Well, the judge is striking the balance.
Right, but here's what I'm saying.
The judge is literally saying...
Let me just lay this out, Bob, real quick, and I'll let you guys take over. I'm not talking about when we have a trial and the jury's in there bringing them in shackles. I'm talking about all the pretrial publicity, all the pretrial motions and the papers and the evidence that the defense inevitably tries to hide from the public. Just let it all out. Let it all out. Let the public see it. Because if someone is so influenced by that, they're not going to be on the jury. They cannot be fair and impartial.
Vinny,
you're going to be left with the outliers of society. I know.
I don't know how you're ever going to get a fair.
You don't want the outliers of society. The point, this is not how death penalty cases go. This is not how it happens. When you're voir direing people on a death penalty, 90% of the time the defense is telling the jury the facts. They're telling them what the evidence is going to show and asking them, despite that, would you still consider him innocent until proven guilty? Would you still consider the mitigating factors not to impose the death penalty? Let's be clear here what's happening. These defense lawyers' goal is to save the man's life. They have no delusion it's going to be a not guilty. The evidence, I've tried death penalty cases. It comes out before the jury in voir dire, and they're asked if they could put their opinions aside and still give a life sentence. All the rest of what we're debating here is nonsense. He should come in his street clothes so there's not an undue influence of photographs being taken. He shouldn't be in shackles. The judge struck the perfect tone, but make no mistake about it, this jury ultimately that's picked is going to hear what the facts of the case are about before they're selected.
Casey Anthony was a death penalty case, exactly. And Casey Anthony, every piece of evidence was public before the trial started.
Every single piece of evidence was public, and it actually helped her.
You're talking about a case right now. You're talking about a case right now. That's okay. You're talking about a case right now where a lot of the evidence is out. However, as a defense lawyer, unless the case, and maybe that's this case, I don't know. But in cases where I'm trying a case, I'm not conceding the victory to the state at the voir dire stage. Yes, I am asking some cases. I'm asking the questions to the panel. Can they, like, for example, I may ask, can they, if I have a defense, can they accept this defense? I need to know if, for example, let's say it's a necessity defense. Can they accept a necessity defense? And you're allowed to voir dire on those, because to make sure that they're able to accept your defense of the case. However, in this case, and Bob, and maybe this case is the case where they don't have anything and they're trying to save his life. Maybe that's the case. However, that's not every case. In some cases, especially in most cases,
but Rick, not respectfully, as I get what you're saying, and maybe you have the unique case, but I'm telling you, as a prosecutor who's prosecuted death penalty cases, you don't go to that death penalty dance unless you are prepared to win the guilt phase. The defense attorneys are on their back. They're just trying to save the guy's life another hour, another minute, another second. That's typically what's going on. If the evidence here, if you were the defense lawyer, if the evidence here was strong towards guilt, are you going to go in front of a jury and try to say, hey, he didn't do it, it's not him, and then be in a penalty phase saying, well, it is him, but don't kill him?
And maybe in those cases, maybe that's, and I'll acquiesce to you, because I've not done death penalty cases. However, it may be in this case, that's what you do. But that's not, but to sit here and say that that's what we do in every case, that's just not it. I mean, there are cases where we have a defense and we put that defense on. We tell a story and try to get the jury to
let me just say,
come to our...
And that's...
We're out of time.
And that's happening here.
Yep. Casey Anthony, there were only 16 people who didn't think she was guilty. 12 jurors, Casey Anthony, and her defense team. That was it. Everybody else down there had a strong, strong opinion. Didn't impact the verdict one iota. All right. Think Tank staying with us. When we come back, we're going to be talking about Rebecca Harrow, the mother of baby Emmanuel. What is she going to do? What is she going to say? What is her defense going to be? What is her husband going to do? We got a lot to talk about.
Now, back to the Court TV podcast.
He was abducted last night from Big 5. Somebody struck my wife while she was trying to change his diaper. And we just ask if anybody knows anything to please contact Ukaipa Police Department.
Don't hesitate, just call.
His name's Emmanuel. He's 7 months. He's 7 months old. This is what he looks like. He's just a baby. Just give our son back, please.
He was wearing a black onesie with a Nike swoosh on him. If you know anything, please come forward, please. Please bring us back our son safe.
So there was a little tell there. That's Rebecca and Jake Harrow pleading for help to find their missing son, Emmanuel, right? To me, the tell was when Jake Harrow shows everyone the piece of paper and it literally says missing kid. Like I understand that, like, we use the phrase, oh yeah, it's, you know, we got another missing kid. Like, you literally don't write missing kid on the flyer for your missing baby, right? But he did. That, to me, that was a tell. Also, his emotion. So they had the story that the guy comes up, says hola, knocks Rebecca out, steals the baby over at the Big 5. Well, that kind of went by the wayside, at least for Jake, because this happened.
How do you plead to the charge in count 1 of the amended felony complaint, a violation of Penal Code Section 187A?
I'm guilty.
And for clarification for the record, that's going to be in the second degree?
Yes.
Sir, do you admit that you committed a violation of Penal Code Section 187, Subdivision A, a felony, in that on or about August 5th of 2025, through and including August 14th of 2025 in the county of Riverside, state of California, you did willfully and unlawfully murder baby Doe, initials EH, a human being.
He pleaded guilty. He admitted that he murdered his baby. Not a plea deal. It wasn't prosecutors saying, okay, here's, no. He just pleaded guilty to the charges. They charged him. He said, yes, I did what you accused me of. No deal. So this is significant now because of the calendar and the timing of all this. We've got to read between the lines to figure out what may happen here now. Take a look. November 3rd, Jake Harrow will be sentenced. Okay, he pleaded guilty. That will be his sentencing. On that same day, Rebecca's defense attorney is going to be in court. Rebecca will waive her appearance. She's not going to be there regarding a pending objection. They're just going to deal with it that day. But Rebecca's not back in court until next year, January 21st, for her felony settlement conference, which was supposed to happen today, but they delayed it till January 21st. So he's going to be sentenced before she has her final conference before her trial date. So what does this mean? Because he's not getting a deal. It's not a cooperation deal with the state. He didn't say, okay, in exchange for this, you give me that. No, he just said, I did it. Sentence me, judge. Let's bring back to the think tank Bob Bianchi, Rick King, Dr. Sue Kornbluth. Dr. Sue, do you think there's any chance that Jake gets sentenced and then comes back next year and tries to rescue Rebecca by falling on the sword saying, I'm the murderer, I did it, she did nothing?
I'm not going to bet all my money on that one, okay? I think this was such a troubled relationship from the beginning that mark on her face that we saw, I really believe that he is the one that did it. And I think he sold himself under the bus because he is guilty. And I think he is the one that murdered their baby. And I also think he's not going to come forward and say that, oh, I did it and she's going to get off. There's so many questions here, Vinny. Was she truly involved in this, or was she being abused by him and under his control? Or was she a part of this as well? We just don't know. There are so many unanswered questions. But no, I do not think any underturns. He's going to come back and try to rescue her. He already pleaded guilty, so he is guilty.
What's going to happen here, guys?
This is a really problematic thing, Vinny. I don't understand their laws, but a prosecutor never wants to split up their homicide cases with co-defendants. This case is set up, teed up for the defense of the woman to say, I am a battered woman. I've got a bruise on my face. He was not only beating my child. Now, there's a neglect issue here. There's no doubt about it. But nevertheless, he previously had been convicted for brutalizing another baby out of another marriage, fractured skull, broken arms, ribs, where he got a suspended or 180-day work release sentence. And so you can imagine her attorney is going to be pointing to him, and that after the fact, she was just covering because she was in survival mode. Now, if he then decides he's going to testify on her behalf, because there's nothing constraining him to do that, because the prosecutors have no teeth into him right now, he'll be sentenced, signed, sealed, and delivered. He can come right back and support that defense. Tough case for the prosecutors for her, I predict.
I think that's the only way it can go at this point. I don't see it going any other way. He basically teed up her defense, and whether he goes in and says anything and testifies or not, you as Bob pointed out, you better believe that her lawyer is pointing directly at him all day, all night. That's all they're going to do.
And so, Rick, how do you explain because her initial story was very specific. Hola man said hola and knocked her out. What's the explanation? And is she the one who has to get up on the witness stand to explain it?
I think that's a tough call right there. But I think Bob's heated up for that too. She's going to say, I was frightened. He was not only beating the baby, he was beating me. He told me to say this. This is what I said. I think that's what's coming. Whether he testifies is going to be the question, and whether she has to get up to say that, or there's some other witness that we don't know. I don't know.
This story is just so unbelievable. I don't know who's going to believe it.
Go ahead, Sue first. Sue first. Go ahead, Sue. What did you say, Sue?
I was just going to say, I don't think that there's so much evidence here, I think, that she probably was beaten, that she can keep bringing that up, and that he has a prior history of hurting other children. They can say that he also hurt her. She was scared to come out and throw him under the bus and say that he was the one because he threatened to hurt her. So I think she has a very good chance here of getting off, I would say.
The reason her defense is going to be more powerful, Vinny, is they don't have the body. And by not having the body, they can't show a continuing pattern of abuse where she would have been required as a parent to protect that child. It could have been a one-time thing. And that's going to be another powerful thing in her favor and making it difficult for prosecutors. The body, very difficult.
Yeah, from what everyone is saying here, it looks like Rebecca Harrow is in... I mean, it's all relative, right, to people accused of murder, right? Like, we're not balancing it against, someone who is not charged. But she seems to be in a pretty good position for a murder defendant in this case. We only have a couple seconds left here, Bob. Is there any chance prosecutors move on from her and throw a sweet, sweet deal at her that maybe she doesn't even do time?
Listen, if I were the defense lawyer, I'd be trying like hell to prove by mitigation package, polygraphs, whatever evidence I could that she was domestically abused, which is very possible here, and that she did not kill this baby. And if I can let the prosecutors pass the straight face test, I know Rick's going to say she doesn't have to do anything. But the reality is, if they can make the prosecutors feel that they could write this up for dismissal because the evidence isn't sufficient, that's her best shot at a dismissal of the case. Otherwise, they're going to try it and rather just lose it.
Yep, and Rick's not going to say anything because we're out of time. Bob Bianchi, Rick Kings, Dr. Sue Korbluth, thank you so much. Appreciate your insight. When we come back, something else you need to know tonight.
This is the Court TV Podcast.
Time to reveal something else you need to know tonight. Let's take a look at the big board. And what do we have? A load of trouble. That is Austin Drummond. He's an accused mass murderer who's accused of taking out an entire family, but sparing the baby and then taking the baby from the crime scene and dropping him off on someone's yard. Apparently, he is being moved to state prison now out of jail due to repeated disruptions. I will now describe one of those disruptions. Drummond smeared feces and hung papers over the jail's windows, causing a security risk. He smeared feces and hung papers, causing a security risk. We'll keep an eye on Drummond. Right now, I need you to take a look at your television screens. We have a missing child who needs your help. This is Nature Dolores Ziegler. Nature is 16 years old, missing out of Kent, Washington. If you see Nature, pick up the phone, make a call, make a difference. 911, 1-800-THE-LOST, or you can call the Kent Police Department in Washington State. The number's on your screen right now. Let's see if we can get Nature to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.
There you have it. If you want to see more in-depth reporting on the latest true crime stories, you can see me every weeknight, 8 p.m. Eastern on Closing Arguments. Thank you so much for downloading. And as always, please don't forget to hug the kids.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.